How does the lack of positive law status affect enforcement? Without positive law enactment, Subtitle F lacks statutory force and cannot impose legal duties or penalties. This omission renders many IRS enforcement actions jurisdictionally defective. Courts are required to apply the positive law standard when adjudicating disputes involving substantive rights and obligations. The U.S. Supreme Court in Connolly and subsequent cases has held that statutes failing to meet the positive law standard cannot create enforceable obligations. In practice, this undermines the IRS's authority to compel compliance or penalize noncompliance, especially in the absence of clear, enacted law. What federal courts are authorized to prosecute income tax crimes? The answer depends on which type of federal court is being referenced. Under 18 U.S. C. Section 3231, only district courts of the United States, DCUS, which originate under Article 3 of the Constitution, have general jurisdiction to hear federal criminal cases, including alleged violations of the Internal Revenue Code. In contrast, United States District Courts, USDC, are legislative tribunals created under Article 4's Territory Clause. These courts operate in federal territories and possess limited jurisdiction. The Supreme Court confirmed this distinction in Balzac v. Puerto Rico, 258 U.S. 298, 312, 1922, holding that USDCs are not constitutional courts and cannot exercise the full judicial power of the United States. What are the implications of this jurisdictional divide? The U.S. Tax Code, especially Subtitle F, which includes enforcement provisions, has not taken legal effect, see Question 22. Therefore, even if a USDC initiates prosecution under the IRC, its jurisdiction is constitutionally limited and potentially invalid if not explicitly granted by Congress. Furthermore, under 28 U.S. C. Section 1292, U.S. Courts of Appeal lack authority to review certain interlocutory orders issued by USDCs, confirming their limited appellate role. The lawful prosecution of income tax crimes requires both jurisdiction and an enforceable statute, both of which are absent if Title 26 remains unenacted. 24. Are federal judges constitutionally required to pay income tax on their judicial pay? No. Article 3, Section 1 of the U.S. Constitution expressly prohibits any diminution of judicial compensation during a judge's term of office. The U.S. Supreme Court enforced this principle in Evans v. Gore, 253 U.S. 245, 1920, holding that federal judges cannot be taxed on their salaries without violating the constitutional separation of powers. Despite this, most federal judges currently pay income tax on their judicial compensation. This practice is inconsistent with the Constitution and suggests undue influence by the executive branch, through the IRS. Such interference erodes judicial independence and compromises the core function of an impartial judiciary. What are the broader consequences of judicial taxation? Judicial subjugation to IRS authority presents a direct violation of the separation of powers doctrine. In Williams V. United States, 289 U.S. 553, 1933, the Supreme Court reiterated that each branch must remain free from encroachment by the others. Taxing judicial salaries threatens this equilibrium. Public admissions have confirmed the conflict. Chief Justice William Rehnquist acknowledged that all federal judges currently pay income taxes. In Lord v. Kelly, 240 F. Sup. 167, 169, D. Mass. 1965, a federal judge openly admitted that fear of IRS retaliation influenced judicial rulings. Such statements raise profound constitutional concerns.